June 2023 by Soipan Tunya.
That's correct.
Cabinet Secretary for Environment, Climate Change and Forestry.
That's correct.
The sixth respondent in this proceedings is who?
Is the president.
Then, where is the next?
I'll get there. I'll get there. Your Lordship, the cabinet under the Constitution is constituted of the president, and the cabinet secretaries appointed thereafter, and the deputy president of the Republic of Kenya. That's Soipan Tuya is an agent of the presidency. Your Lordship, one of the issues that was before the impeachment was that the deputy president, the petitioner herein, indicated that Kenya is a shareholding country. There are shareholding agreements before you, and that positions either in parastatals or corporations were to be shared in accordance with that share agreement.
Well, that is the reason why his client got impeached. That is not
you will be given an opportunity to ask my case, you will be given an opportunity to respond. Even if you are eating, Mr. Yamondo, take your call. Your Lordship, it is by client submissions that Florence Auma Olwoch may have been a beneficiary of that shareholding. Your Lordship, finally, Your Lordship, we have.
It is extremely unfair and unjust, especially for an advocate to mislead or what you are saying to play to the gallery. Can you read paragraph 12 of the affidavit? So that he does, no. Yes. Let's hear it from him, where he says that the said board is chaired by the president, who has. So can you kindly do it properly so that you don't try to hide? No. Hold on.
Your Honor, the truth is, leadership and my lords, they will have time, as you say, to respond and say all these things. If he's saying nonsense, they will stand up and say so. But this constant interruption is intended to derail this hearing. Let them respond when their time comes. Yes.
And we have heard the condescending nature of the respondents. Everybody here has been instructed by a client either to speak sense or nonsense. So that being the case, the condescending attitude is completely objectionable, and everybody should take their seat and use their time with the sense. If sense can only come from them, they do it during their time.
Thank you very much. Can I finish?
May I be protected by my application and the respondent be granted opportunity to respond?
Finish what I was saying.
You will have your time.
I know I will have to
respond.
But please, this is the application being presented. Let's not have other things that
has been served upon you.
I'm not accepting.
Just one thing.
Your Honor, if I'm allowed to just say something. Applicants finish their case and then people will respond. Because this interjections is just going to affect the conduct of the proceedings. It's very unfair. Let everybody have a chance. Each person has 10 minutes, others have 5 minutes. Let them utilize their time. But these objections in between is unfair and it's affecting the flow.
Come to court and say that.
This is what I want to say. Yes. They're all here. My plea is we conduct these proceedings in an orderly manner. As Professor Ndegwa used to remind us when we were in school, to be an advocate, you are a superior mortal. Can you just be slightly superior and deal with this thing in an intelligent way?
Mr. Ndegwa, you are many times to conclude.
No, I'm also obliged, Lordship. it may be noted that, Your Lordship, that the chair of this board is directly appointed by the president, the six respondents in this case. Your Lordship, may I submit again that the perception out there is that this bench has been constituted for a particular purpose. And the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. Your Lordship, I have annexed a tweet by senior counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I wish to read that tweet, Your Lordship. Ahmed Nasir, Your Lordship, is a senior member of this bar, a senior counsel, and Your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, Your Lordship, the perception out there is that this bench is part of the conspiracy.
Ahmed Nasir is not the law.
Your Lordship,
He speaks not to the law. Ahmed Nasir has also an affidavit. He's not a witness, my lord. How does Ahmed Nasir, and we have 64 senior counsel, how does Ahmed Nasir, how can his tweet inform submission before this court?
may I answer that, Your Lordship, to the good professor, that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, Ahmed Nasir says, and the president's lawyer says, we cannot receive justice. That is the standard. Your Lordship.
Ahmed Nasir says that this court will quash.
Mr. Ojienda, you have your time to respond.
No, but the point is, he then speaks in your favor. Pick that line.
You will not teach me how to submit. You will pick the line that you so wish. For me, I am saying, Your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Finally, Your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated our file to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, you slated our matter for the 29th, and never saw the urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rules 47, is of paramount importance and something that cannot be ignored. Why did the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that we wish to expunge paragraph 16 of our affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular mission. 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Masharia will highlight on the authority with the authority in support of my submissions and those of Eden.
A slight clarification on expansion. Paragraphs 10 and 16, if I had properly.
Yes, that's correct.
Of people supporting affidavit.
That's correct.
I don't know whether we can do that to oral submission. You cannot expurge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number 2, if you expurge paragraph 16,
can you cover it in the response, please?
I may,
Yes,
but
it's just
if you expurge 16, I have a problem with that. There is no application before you. If you expurge paragraph 16 from the affidavit, there is no application has been urged before you. So we know this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expurge is paragraph 16.
Paragraph 16 of this affidavit, my view.
Who's affidavit? The way affidavit
The applicant's affidavit. That is Obuli Namenya.
My Lord, permit me the my Lord, again, because we have to be fair to the court, my colleague has to be candid and confirm to the court. The reason he is withdrawing that paragraph 16 is because the claim there is factually false. Because he can't just withdraw and leave the world thinking
I have not seen that paragraph 16. Can you read it? The paragraph 1.
Your Lordship, are you having the same application?
Read as paragraph 10, which you have to withdraw, and paragraph 16, so that we can consider if it can be withdrawn.
Yes.
and confess it's a lie.
We give Mr. Ndegwa, my lord, your leadership the opportunity to
Yes, yes. Let me read those paragraphs so that we can sit down.
not my agree. I'm just saying, protect him from these tutorials that he's getting from this.
Let's read that paragraph 10.
Your Lordship, I wish to say that most respectively, I wish to say no more with respect to the paragraph.
This direction to court, read paragraph 10.
16, or paragraph 16,
Paragraph 10.
May I have some peace, Your Lordship? How many people are in conduct of these trials, Your Lordship?
Listen.
Who is in conduct?
Listen. Njiri,
Yes, Your Lordship, I read.
you have applied to expand
Yes, Your
paragraph 10 and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expand?
Your Lordship, paragraph 16 says that.
Paragraph 10.
And Your Lordship, may I take note that these paragraphs have been expunged.
One, we have to expunge those paragraphs.
That there has been an application to expunged them. The petitioners have credible information that Honorable Mrima is a close associate to the proposed deputy president, one Mr. Kidore Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is convicted as she should excuse herself, as she was Mr. Kidore Kindiki's LLM student at Moi University.
You have no LLM program at Moi University.
You will have your time to submit, sir. And that's why I'm expanding. That's why I'm expanding this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about? Issues to be made.
In a ruling, because the application has been made and the response is there, that we decline the invitation to expand this paragraph, they will remain as part of the record.
We are most obliged.
Dr. Kamuna, we would appreciate if you want to address us in the course of the as in your submitting. Is that the position?
Yes.
Okay, proceed.
Is that evidence of party?
Are you supporting the motion?
I'm supporting my land friends complaint to be able to have land friends.
You need to go.
Yes.
Yes.
Thank you very much, my senior. My lords, I'll take about 15 minutes. Mercifully, my issues are issues of law. They will not incite any shooting up from a respondent. We should not. My lords, my lords in the leadership, I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Bureau Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Peters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. And the only question before that court that led it to this decision was the question of bias. I invite my lords and your lordship to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared nullity, set aside, and the appeal had fresh. I invite you now to go to paragraph 9. We've done back-to-back a photocopy, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talukan Singh Rai. And the court is saying what it held, and it says this. During the pendency, my lords and your lordship are there, in the middle of paragraph 9, during the pendency of the applicant's motion and the respondent's preliminary objection, this court, in a 5-judge bench decision in Jasbir, and they give the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear and finally concluded matter. In light of the decision in the right case, it was deemed appropriate that since this matter raises similar issues, it be similarly heard by a 5-judge bench, hence the unusual composition of this bench. They are merely underlining the importance of the matter the court is dealing with. Permit me now, your lordship and my lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Jock in R versus Gao. Justice must be rooted in confidence, and confidence is destroyed when the right-minded people that Mr. Ndegwa was talking about go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the fact of impartiality has been done. And this is what they say at paragraph 6. And this, my lord and your ladyship, is what I would be beseeching this court to find favor with when you retire to your will. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own 5 judgments in this Court of Appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with. The appearance of it. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another English case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And we say emphasis added. And I would also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case cited earlier, I think I mentioned it. This is the case of Agostino Pinochet. It actually begins at paragraph 80. There's a long passage, I'll not read it on account of time. But at paragraph 81, they cite the basis for the reason the two applicants before you have moved. It's the Latin phrase, nemo debet esse judex in propria causa. No man is to be a judge in his own cause. Then at paragraph 82, Lord Hope, in the same decision, indeed, it may be said of all the various tests which I have mentioned, including the maxim that no one may be a judge in his own cause, that they are all founded upon the same broad principle, where a judge is performing a judicial duty, he must not only bring to the discharge of that duty an unbiased and impartial man, he must also be seen to be impartial. Having considered all those, the court, and in that case, what the issue was that the late Justice Laka had represented one of the parties previously, not in this matter, but previously. But at paragraph 86, they give a summary of what I've told you, and then go to paragraph 88, and then this is how the court finally resolved the matter. And I'll also recommend to you paragraph 90. Let me read paragraph 90 before going to the conclusion. The mere probability or appearance of bias was enough to breach the cardinal rule of fair trial in the administration of justice. Having raised the issue of bias arising from the same circumstances in the hearing of an interlocutory application by the same judge in a matter involving the same parties, we do not understand why the applicant's counsel failed to raise the issue during the civil appeal. That omission notwithstanding, the seriousness of the bias, of the issue of bias, cannot be underrated. As observed in the Benjo case, bias is one of the grounds that will justify review of a previous decision of the Court of Appeal. As I say, this was the first time it's ever happened in the history of the Court of Appeal, and as far as I'm aware, the only time it has happened. So in paragraph 85, this is what the court says. Accordingly, we allow this application, declare that there was a failure of justice in the judgment dated 4th October 2002, and we accordingly invoke the court's residual jurisdiction to correct that injustice by reviewing the judgment and setting aside with all the consequential orders. Now, my learned friend, Mr. Kibe, has referred you to a passage that my good and learned friends, the respondents, insisted must be read. And this is a question of the attendance of a wedding where gifts are shared by a judge, who the gifts are received by a judge by a party who is before this court. We are before this court because the first petitioner was impeached in the Senate. The Speaker of that Senate is a party in this case. In the document presented by Mr. Kibe, the Speaker describes the judge, and there's nothing wrong with having friends, as I should say. Let me say this. He says, my long-time friend. This is what he says. Now, we found a decision, and I've shared it with you. This is the case of Nabi, where on all fours, a similar situation occurred. And I invite the court now to look at paragraph 70 and allow me to read this, because I won't be reading anything else after I read this. This is what the court, this is, I said, is Naveen Kirai versus Virunga Limited. I believe so. I say paragraph 30, please forgive the coloration of the authority. And this is a 2022 decision. So both the Standard Chartered case and the case before you were determined under the current constitution. And as I'll be demonstrating here, they also took into account the judicial code of conduct. I'm reading from paragraph 17. In this matter, the third respondent declined to recuse himself. This was a matter of an arbitrator, appointed under Article 159. Declined to recuse himself on the basis that the relationship between him and the counsel for the first and second respondents was a professional one. This court, however, takes judicial notice of the fact that in the Kenyan context, invitations of colleagues to weddings is extended to those that one considers close, and such invites are not extended to all and sundry. Had that been the case, then the third respondent could have as well extended the invite to the counsel for the applicant who is an advocate just like him. Given the circumstances, this court arrives at the inevitable conclusion that apart from being a professional colleague, the third respondent and counsel for the first and second respondents are friends. And that is the perception that any reasonable, objective, informed member of society would reach based on the circumstances of this case. I continue paragraph 21. As counsel for the applicant stated, it is common knowledge that there is a custom for invited guests to give gifts at a wedding, exactly as happened in the case Mr. Kibe showed you. In this case, apart from the third respondent and the counsel for the first and second respondents, the applicants and their counsel will never know if the counsel for the first and second respondents was a gift-bearing guest at the traditional wedding or not. In this case, we know because the photograph depicts a gift. It, however, boils down to the failure by the third respondent to disclose to the applicants and their counsel that he intended to invite the counsel for the first and second respondents to his traditional wedding and seek their views on the same. I need to emphasize that the real issue here is not that a wedding was attended. It is that that issue was not disclosed prior to the hearing and dismissal of an application in this matter and the continued conduct of this proceedings. I continue. Bearing in mind the final nature of arbitral awards, which can only be set aside upon a litigant satisfying the conditions stipulated under Section 35 of the Arbitration Act, the need for disclosure becomes even more critical. Paragraph 72. In S versus Roberts, the court stated that the apprehension be that of the reasonable person in the position of the litigant and that is based on reasonable grounds. I continue at paragraph 73. The counsel for the first and second respondents has stated that since he and the third respondent are arbitrators who have served at the Chartered Institute of Arbitrators, Kenya branch, as chairman and vice chairman of the institute respectively, during the same tenure, they were bound to interact or have interacted in the Chartered Institute of Arbitrators events, trainings, board meetings, and members' welfare gatherings were discharging their professional mandate. I do agree that the above events are professional in nature. However, weddings are personal events where families, friends, and close colleagues are invited. The lack of disclosure by the third respondent that he had invited the counsel for the first and second respondents to his traditional wedding is one that leads to the perception of bias. Due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence that applicants have that he will be neutral when it comes to the hearing and determination of the arbitral proceedings before him involving the parties hearing. In conclusion, this court holds that there was lack of transparency on the part of the third respondent, and he should have done the honorable thing when he was requested through an application challenge to recuse himself from the arbitral proceedings in nature. This court finds that justifiable doubts have risen as the third respondent's impartiality and independence, and the same have been proved by the applicants. This is a decision, and the only one we could find that addresses on all fours the issue that confronts these courts. I ask this court to find favor with this decision, to recuse itself, and I do so with tremendous respect. It's just that the nature of the matter, the nature of the issues, and the perception as such as are captured in that decision. Recusal will be the only thing that will do justice not only to the applicant before you, but to the court itself. Thank you for the privilege of your attention, for the time. Unless you have any questions, I'll start asking.
My humble submission that your Lordship must exercise flexibility. The usual case law getting recusal is inapplicable in this case. As a matter of fact, I will state you very respectfully. If there are parties, and if there are who do not want or who do not wish to see you hear this matter, please walk out. You are not the only judges in the country. Let another panel of judges be appointed to hear this matter.
My Lord, if I can say so, very respectfully to refer to my own history. When you reach my age, you keep on looking at your history. I remember there were one or two expatriate judges, colonial judges. The moment you said to him, or yeah, to him, between the lordship, I would like you not to hear this matter. I want you to speak yourself. His response was, okay, if you don't want me to hear this case, let another judge here. That is the attitude. Those of us who have had the advantage of receiving higher education know when you're dealing introduction of philosophy, you are taught that perception, the first course you take is perception and reality. Perception and reality. When you're studying philosophy. Perception is a very important concept when it becomes the arena of politics. Reality may be completely different. And indeed, I believe it is different in the case before the Lordship. I appear before you very often. I've never entertained any idea about your standing in relation to justice. But the perception now that has been painted by my able learned friends, clients, Mr. Ndegwa, Mr. Kibe, and Mr. Mutahi, that there is a sizable portion of the Kenyan population which will not be happy to hear you sit and listen to this case at all. And may I remind your Lordship very respectfully, impeachment is politics of the country. There's no way you can move away from that at all. I would respectfully refer you to a book I've taken the trouble to read.
Your Honor, sorry for the interruption. You are muted again. Perhaps you could be unmuted so that we follow the proceedings.
I wonder why it has happened in respect of the community. Can I speak now? Can I speak?
Yes. You know the
Yes.
Yes. Your Honor, there is a book here, Politics of Presidential Impeachment. Politics of Presidential Impeachment. I've taken the trouble during the weekend to read this book. Impeachment is politics of the country. There's no way you can remove it from the politics of the country. And that's what I'm saying very shortly. That as you have been told, there are some people who feel very strongly that it is not here to stay. Get out. Let them get out of justice to hear the case. You have no best to do this in the matter. There's no reason for you to remain in the case when other people you wanted to hear the case at all. May I remind you, my lords, we are hearing impeachment cases, advocates to be able to think broadly and bring to your notice the culture of the people that you are serving. There is a little phone that is a phone that is found by a little girl in Kenya. Those of us who listen to the Kenyan radio may have heard of it. He says in Kiswahili, Kenya ni nchi ya watu wa akili kidogo. he thinks very beautifully. Kenya ni nchi ya watu kidogo, na wanataka kitu kidogo ndio wafanye kitu. Majority of our people are not the people who are in this country. Majority of our people are people who have not had the advantage of receiving the education, the training, that the judges and the advocates, the members who are within the. And as one of my own friends very aptly pointed out, majority of the people believe that the case before you has been engineered by the politics of the country. And if some of them believe that your lordship cannot hear them, again, I say to you very, very respectfully, you stand to lose much. You better leave the case, let other people hear the case, and you continue to maintain the. My Lord, to go back to the politics of issue, this matter was passed as in National Assembly. National Assembly very overwhelmingly stated that the deputy president has been impeached. It was then referred to the Senate, and the Senate again said very overwhelmingly that the deputy president was guilty and convicted him. My Lord, the stories that one hears in the streets of Nairobi, the stories that one hears elsewhere, you can't afford to pay. I don't even know it. Stories that members of parliament were each given handsome money, amount of money. That may be so, or may not be so, but it doesn't matter. They have made the point. The members of parliament received bribes, and they handed down a decision which majority of people believe that it was a corrupt decision. You cannot afford to ignore that. Now, when you go to the Senate, you are told the same thing. That members of the Senate received money in what is called quite partial, quite partial. They received money from known people. Again, you cannot afford to do that at all. Now, when they come to the judiciary, they expect the best. They expect people who have got integrity. They expect people who can hear them and who they cannot suspect at all. But if then they are suspecting some people, whether truthfully, whether honestly or not, it is my humble submission, the natural thing as a judge, if I was sitting where your lordship are sitting, I would say, as Hanino, I'm walking out. You will not say it. It is the judiciary that people have got confidence in. That's why I remind you, lordship, very respectfully. It is the judiciary that people of Kenya actually are respectful. It is the judiciary, the judges, that people think that they can do good effects. When we had a problem in the year 2007, it is the judiciary that served the country. When we had a problem recently during the time of President Uhuru Kenyatta, and the matter went to the Supreme Court, it is again the judiciary that saved the country. Now, if you find that people now are questioning the very institution of the judiciary, it's my humble submission that as a judge, just move on. Say thank you, I'm moving out. That does not necessarily mean that there is something wrong with you at home. And as I said, my Lord, I've spent many years appearing before your lordship with the Justice of Order in Mombasa. At no time did anybody ever open his mouth and say to me that, Kamenwa, this Justice Okola is this, is this, is this, is this. Nobody ever did it. I want to suggest to Mulimo, I've had the privilege of appearing before you in many cases. There are cases where you have given me ruling. There are cases where you have not given me orders at all. But at no stage did I ever entertain an idea that there is something wrong with Justice Mulimo. We have confidence in all of you. But now we have this concept of perception. There are some people who feel very strongly that Justice Okola should be out. Justice Mulimo should be out. I let Judge now say, I'm letting you, I'm not dismissing against you. I'm one who has fought for rights of women. And I kept on shouting very loudly that you want women judges. And I haven't had the fortune of appearing before you very often. I was sorry, my memory is letting me down. But my Lord, may I say, I have had the opportunity of appearing before you. And may I say this most, my Lord, if you go and check the Judicial Service Commission record,